In this talk, we're going to talk about Chapter 9, Contractual and Title-related Problems. Previous chapters have highlighted the concerns regarding select-type properties, but in this chapter, we're talking about the contractual issues, including assignment of offers, complexities regarding rights and liabilities in this regard. In this chapter, we're also going to analyze insurance in terms of available coverage as well as problems that the buyers can encounter when attempting to secure insurance for older properties, outdated systems, and other items that insurance may not readily accurate claims. Heritage properties also going to be discussed here, and we also will talk about title-related matters concerning access to property, fencing issues, shore road allowances, and shoreline ownership. So let's dive into it. The first thing is assignment of an agreement. So before we go, let's talk about the contractual issues. Four contract-related topics that can cause problems for dual instance are discussed here: obtaining an agreement, obtaining insurance, heritage properties, and power of sale. Assignment refers to the transfer of right in a contract, usually in writing to another party. The general rule of law is that contracts are assignable with certain rare exceptions like personal service contracts, which are not assignable. So, in general, all the contracts are assignable unless they are personal service contracts. Agreements of purchase and sales clearly sets out the party to the agreement. However, circumstances can arise in which one of the parties want to assign the contract. Liabilities versus right. As a general rule, liabilities under the contract cannot be assigned by a party obligated so as to compel the other party to exercise by under the third party. However, liabilities can be assigned if they are with the express consent. Rights as opposed to liabilities under the contract can usually be assigned except where for reasons of confidence between the parties or personal qualifications such as action would increase or change the obligations. For example, in the case of a seller take-back mortgage, the court would not imply an intention to permit an assignment without the consent of that seller. Assignment by the buyer. If a buyer contemplates assignment of the right to a corporation or any other party prior to the closing, a clause in the agreement of sale can provide that the buyer has a right any time prior to closing to assign the offer and be released from any further liability in regards to the obligation of the contract. The seller should carefully consider this type of assignment as no recourse against the original buyer is possible. This clause should not be used when the agreement or the contract involves a seller take back mortgage. Assignment clauses. The kind of assignment clauses are like in the scenario where the buyer has purchased a property and now wishes to assign the agreement of purchase and sale to another party. The clause assumes that the buyer has the right to assign the agreement. There could also be scenarios where the buyer has purchased a standard condominium unit and now wishes to assign the purchase or sale of equity to another party, or a buyer is purchasing a property and wishes to assign the right assign wishes to have the right to assign the agreement as their own option as an applicable clause inserted in their offer. So essentially, assignment of prior agreement or assignment of prior agreement in case of a condo, and assignment and right to assign agreement. A builder, there can also be scenario where a builder has sold a home to the buyer and includes a non-assignable provision in the agreement, which includes the builder's right to grant an assignment would always consent. To summarize, right under assignment are generally assignable and subject to certain exceptions. Legislation should note that some agreements may consider a non-assignability clause or a right to assign only with seller consent. Liabilities are not assignable without the proper party's consent. If an assignment does not occur prior to that consent, the original buyer has the continuing liability. Expert advice is strongly recommended for all matters concerning assignment. Assigning a lease. The tenant may sublet or assign at will. Tenant may sublet or assign at will without the approval of the landlord unless the lease stipulates otherwise, or the tenancy is residential and pursuant to the Residential Tenancy Act. So to rephrase, a tenant may assign or sublet at will without the approval of the landlord unless the lease stipulates otherwise, or the tenancy is residential Pursuant to the Residential Tenancy Act. Special consideration also apply in the case of a care home under the Act. Provisions concerning residential assignment are were discussed earlier. Assuming that the lease in question is a commercial and necessary permission to assign that commercial tenant may transfer all of his interest to the new tenant. However, unless he or she is relieved by the landlord, the signer remains liable for the lease obligation to the landlord. Of course, the signer may not remain liable if it is such a specifically set out in the lease terms. Subletting. If a tenant transfers something less than the entire interest, then he or she is subletting it. This may this may be either subletting a part of the term or the part of the premises. The tenant remains liable to the landlord unless otherwise stipulated by the lease. Once again, residential subletting is subject to the Provincial Residential Tenancy Act. Most commercial leases offer an express covenant that the tenant will not assign or sublet, or a qualified covenant that there will not be any assignment or subletting without the prior consent of the landlord. This this clause may be further qualified so that the landlord consent will not be withheld arbitrarily. In these cases, in these circumstances, the tenant can apply to a judge to obtain. In these circumstances, the tenant may apply to a judge to obtain approval for an appropriate tenant whose who intends to use the premises who intends to use the premises in a reasonable manner. Usually, both tenant and assignee or subtenant will form a sign will sign a form agreeing to the bond by the main lease, and the landlord will consent to the agreement. The parties will pay the landlord a reasonable cost and related expenses in arranging for this consent. Obtaining insurance. Clause 8 in the agreement of purchase and sale provides that the buyer may make inquiries that the principal building may be insured against risk of fire. Historically, this clause suffice given very few problems in obtaining coverage. These days, insurance underwriters closely scrutinize properties, particularly older homes with outdated wiring, underground oil tanks, or other matters requiring remedial action. An insurance condition may be required to provide an opportunity to seek out appropriate insurance coverage. Insurance overview. An insurance policy is the agreement in which one party or insurer agrees to pay a sum of money to the other insured party if the latter suffers a particular loss in exchange for a premium paid by the insurance. The insurance comes under residential, commercial, or a condominium. In case of residential insurance, the coverage is generally grouped under owner and tenant policies. Both types are commonly packaged. That is, various coverages included within a single policy. Most consist of four basic sections. Property coverage covers what property is being insured against loss or damage, what is not insured, and what type of causes of such loss or damage that will be paid under the policy. Liability insurance includes a specified limit for liability arising out of accidents or occurrence as detailed in the policy. Liability can extend to specific personal action liability, premises liability, tenant legal liability, and medical payments, endorsement. Additional coverage that is added to the insurance policy, for example, coverage is relating to valuable personal articles and policy conditions. Various policy conditions relating to the procedures concerning claims and general policy provisions and matters addressed in applicable provincial insurance legislation. Commercial policies are structured to provide basic coverage for property insurance and liability coverage with additional endorsement and other policies to meet the need of the specific business activities. There could be boilers so a commercial policy would include the boiler and mechanic and machinery coverage, errors and omissions, fidelity bond, loss of income, and multi-peril risk. Condominium the insurance for a condominium consists of three separate groups. Condominium corporation. The condominium corporation requires insurance for the unit structure and common elements. In addition, the corporation is responsible for liability coverage, any bonding coverage required for employees, and the unit hours should ensure any improvements and renter should ensure all personal items. Uh, let's talk about the heritage clause property. Ontario Heritage Amendment Act gave greater municipal and provincial powers to protect heritage sites. Real estate perspective, there can be clauses in the agreement of purchase and sale, like for Ontario Heritage Act in cases of Ontario Heritage Act designation. Ontario Heritage Trust Agency, of which is the Agency Ministry of Culture, is actively involved in protecting and promoting Ontario heritage. Municipal Heritage Committee assists and advises Municipal Council on local heritage matters, consists of 5 or more people. And Conservation Review Board or CRB conducts hearings and make recommendations regarding the heritage matters. Key statutory provisions: Part 4 of the conservation of a property of cultural heritage value or interest makes a no alteration or demolition can be done without written consent. Heritage easement agreement. Part 5 of the heritage conservation in district, and there's a tax relief program which allows 10 to 40% of like taxes. Power of sale, contractual, they can do power sales. The contractual power sale and statutory power of sale. Contractual power sale is pursuant to the appropriate clause in the mortgage agreement, mortgage document, and statutory power sale is a no clause. Power of sale is basically a right of the mortgagee to force sale of a property without judicial proceeding should a default occur. Listing and selling process. So, Form 1, notice of sale under mortgage can be sent within 15 days following default. Mortgager has 35 days to remedy under the contractual power of sale and 45 days under the statutory power of sale. After 35 days, the 45 days have passed since the notice of sale under the mortgage, the certificate of power of sale or a form 262 can be sent. Clause in the agreement about power of sale has the general provisions. Sell a mortgage can insert clauses. Marketing. So it's important that at least 2 appraisals are done to ensure there is reasonable timing, um, widest possible coverage, and arm's length transaction. Seller selling under power of sale is used in conjunction with Form 100 agreement purchase and sale. A seller selling property as is and without the guarantee of inclusion of chattels or fixtures. So let's talk about the title related problems and disputes. There can be issue with the road access, year-round or seasonal publicly managed roads, privately accessed roads need to be looked at.